We are ready to get started. Welcome to this HAI seminar with Shazeda Ahmed. It's my pleasure today to introduce the speaker and moderate the panel. A couple of words first about logistics. So my name is Angèle Christin. I'm an assistant professor in the Department of Communication at Stanford, and I'm going to be taking in the question. So if you would like to ask questions to Shazeda, please log in to the Slido website. You can see here on the screen the way to get the QR code, and you can submit the questions on the website that it will take you to. I will be monitoring the website and taking the questions from there. So please do that and tell me in the chat if you don't manage to do it, but it should be much easier through Slido. A second word about logistics. Our event is going to be an hour long, and so we are going to have Shazeda talk for 30 to 40 minutes, and then we're going to turn to the Q&A. Okay, so with these logistical points out of the way, it is my pleasure today to introduce Shazeda Ahmed. Shazeda is a doctoral student at the University of California at Berkeley at the School of Information. She's currently a predoctoral fellow at two Stanford University research centers, Institute for Human-Centered Artificial Intelligence, who is sponsoring this event, and the Center for International Security and Cooperation. She's worked in a variety of places at Upturn, the Mercator Institute for China Studies, the Citizen Lab. She was also Fulbright at Peking University Law School in Beijing in 2018-2019. And from my perspective, let me just add that I think that Shazeda Ahmed is doing the most fascinating work right now about the role of digital technologies and the concrete applications of digital technologies in the Chinese context. And I first became acquainted with her work a couple of years ago when she published a well-remarked article in Logic magazine about the Chinese social credit system, where she argued against the kind of hype that the kind of Chinese social credit system was creating, and I think articulating a particularly like smart and just wonderful critique of how the system actually works, what it's actually designed to accomplish, and kind of pushing back against media representations and kind of, somewhat dystopian representations of what the social credit system can do and what it cannot do. And so today she's going to be talking about another paper, which I think promises to be equally exciting, about In the Shadow of the Smart Court, Challenges to Fairness, Transparency, and Accountability in China's Application of Courtroom AI. Shazeda, the floor is yours.
Thank you so much for that wonderful introduction, Angèle. I'm going to go ahead and share my screen. Great. Okay. Yes, thanks so much. And before I go into this work, I want to acknowledge that this was a project in conjunction with one of my mentors in Beijing, Professor Xin Dai. He writes in English and in Chinese. He's prolific. He did great work on the social credit system, and he is the law expert. So I will explain some things that I think are pertinent to the lawyers and legal scholars watching. But ideally, the conversation I'm hoping is structured more around the socio-technical aspects of this work. So to talk a little bit about what the work is responding to, there's kind of two things I think I need to cover with everyone. So one is when Xin and I were talking about the Smart Court project, which has been written about extensively in China, we were kind of first wondering, well, what is the landscape of writing about courtroom automation? And typically, as with a lot of tech topics, it starts with what is happening in the United States. So I'm sure people are familiar, especially if this is kind of a topic area you work on, with how much has been written and investigated on pretrial risk assessment, sentencing, bail, automated systems for determining those things, and kind of the deeply seated flaws in them. I feel like that, when we did our literature review, that's most of what's been written about. Certainly there's some things about kind of automated dispute resolution, which I won't really be talking about very much today. And I also want to flag kind of this newer direction some of this work is going in. So Daniel Klutz and Deirdre Mulligan, looking at the legal profession itself and some of the automated systems and practices coming into that. Like, we don't even necessarily think of that as courtroom AI because it's what happens before you reach the courtroom, but it's also incredibly important. And in the kind of legal tech world, there's quite a bit of this happening in China as well. I also wanted to kind of acknowledge that why we chose fairness, transparency, and accountability is because these are kind of the three values that come up the most in Western-centered conferences and papers around machine learning. So I'm sure people have heard of FATSTAR, now going by FACT. And fairness, I think, of these three values gets written up kind of the most at conferences like FACT. Here are a couple of examples of papers that talk about not only kind of like technical means, but also social means of determining what counts as fairness. I want to acknowledge before we go into kind of blowing up some of these expectations when talking about China that there isn't necessarily even agreement about what constitutes fairness in the United States. Here's some work that kind of looks at like legal and kind of other like historical context to explain why we're still struggling with this issue. And so when I was talking to Shin about like, how do we want to write about this in relation to China and why is it important and different in China? It was partially to use China as an example to, again, break with some of these expectations that values like fairness, accountability, and transparency are what everyone everywhere, not just in the US or Europe, want. So we were going into it looking for, are these the terms that come up when they talk about developing kind of automated courtroom technologies, or is it something else? Are there other values? And are fairness, transparency, and accountability defined the same way in a single party, fairly top-down state? Some of the questions we were asking when we were looking at Chinese kind of law scholarship, what specific companies were building and selling some of the main technologies being used in courts. So, looking at news media coverage, company marketing materials, were, how are these technologies designed to achieve these fairness, transparency, and accountability goals? And what are the additional values they claim they want to achieve? Where are the points of resistance or failure to meet the goals? And are they acknowledged? What are the solutions proposed when these points of resistance are even brought up? And of course, the question I'm always interested in all of my work is how these institutions come together to build the technology and deploy it. And before even getting into that, all of this is really lots of stage setting. It's important to ask how courts view the problems of the judiciary and what the solutions they're proposing are. Does that explain the sort of rationale for the technology? And one big component of this is professionalizing the judiciary. So, whether it's, certainly there's China's Supreme People's Court, there's kind of like intermediate courts, there's grassroots level courts. There's this idea that judges were not being necessarily consistent or fair across all of these different courts. So how do you raise the bar for what it takes to be a judge? And will that iron out some of these other issues? And informatizing the judiciary is the kind of phrase that this gets captured in. I have tried to kind of write about what informatizing means. I'm certain there's better scholarship on this, but for a kind of short reference, I think of it as being really similar to how Shoshana Zuboff in her older work described informating, which is kind of creating information around processes that like lead to, their evolution or change based on the information you've gathered. And so there's three sort of phases of court informatization that show how the Chinese judiciary has evolved in its thinking about what technology is supposed to do in the courtroom. So the Supreme People's Court, the highest court in China, had developed a 5-year plan in 1999, and the goal was to connect courts across China on a unified computer network. So this was court informatization 1.0, and it was about setting up the basic ICT kind of infrastructure for government that would be used across the country. It would make paperwork processing more efficient, allegedly make collection and reporting of court data more reliable. The 2.0 phase, so in the early 2000s, was setting up platforms to improve both internal communication and control, as well as services for external stakeholders like litigants, other government agencies, the public, the media. So this was, creating kind of like digital workspaces for within courts. You know, judges, clerks, and staff could kind of communicate, pull up digitized records. You know, there are a lot of like logistics around that. And then there's this huge leap, right, in 2017 for court informatization 3.0, which is where we are in the present. And the centerpiece is the so-called Smart Court project that's trying to transform the judiciary using kind of alleged big data and AI, very like buzzy technologies to make court proceedings kind of more routine, and through that achieve some of these other goals. So the Supreme People's Court also it has been really involved in like setting out what that should look like, and they want there to be more kind of customized services for litigants, for judges, government agencies. I also want to talk about this transition. So something I didn't mention is that there was a period kind of, you know, in 2017 to 2019 with court informatization 3.0, we're trying to establish internet courts. So the name kind of captures two aspects of why they're called this, right? One is that they only deal with, their proceedings are all done online. So it's through video streaming platforms. And internet courts only deal with issues that pertain to activity kind of happening on the internet. So that can be, you know, things like consumer contracts, online torts, you know, internet IP infringements. And so the entire cycle of proceedings for these are done online, from case filing to discovery, kind of court administered mediation, trials, and hearings. And it creates this opportunity for a lot of China's biggest tech companies. So you have Ant Financial's Alipay, which is the biggest mobile wallet app, right? The payment of like court fines can be done through that. WeChat, which is, you know, if it hasn't already hit 1 billion users in China, it's pretty close. It's the biggest messaging app. It has like mini kind of applets called mini programs embedded within them. You could do a lot of the filing and internet court work there. And internet courts, there are 3 that I know of so far. One is in Hangzhou, there's one in Beijing, and one in Guangzhou. They can take cases from anywhere in the country. So that also kind of differentiates them from kind of traditional physical courts. And between 2017 and 2019, researcher Alice Mingay found that the court, just one court, the Hangzhou Internet Court, had already taken nearly 2,000 cases, and the average time of an entire hearing was about, on average, 28 minutes. So again, these are kind of like these big claims of efficiency gains from these courts. And now, so moving into smart courts, their goal is to offer litigants data analytics that can be used to inform them about cases that resemble theirs and how they've been decided in the past, and to help them predict the likely outcome of their own case. So this might on its face sound not terribly exciting, but it's actually really powerful, because it could determine whether or not a potential litigant thinks a case is worth pursuing in court, and potentially dropping it if their understanding of the data is that they don't stand a chance of winning the outcome they want. And finally, the courts, one of the components of smart courts is analytics about judges' performance. So going back to this state-imposed goal of professionalizing the entire kind of position of judges, there's essentially records of judges' decisions and whether or not they deviate from a few technologies we'll discuss after that suggest particular outcomes. But it's in one sense, it's like an accountability check on a judge. And of course, COVID-19 has accelerated all of this. So basically, prior to the pandemic, there was this goal that courts should, more and more courts should essentially adopt the live streaming platforms and some of these technologies. But of course, because of the pandemic, many courts had to shut. And so there was this push to, basically roll this out to as many courts as possible. And I think it kind of jump-started some of the state goals that people hadn't anticipated would be achieved, by 2020. So I wanted to talk about alternatives to some of the values like FTA, and we will get into FTA in a bit, but something that came out quite early for me and Chin when we were doing this research was the concept of efficiency as a value. And, I personally am often allergic to this idea. You see so many tech companies talk about making things more efficient, but I think it's worth acknowledging that for a lot of people in China, this is actually really important, right? Bureaucratic processes are involved. They take a lot of time. Not everybody has the resources, including time, to kind of spend trying to achieve the outcome they want, or particularly achieve what they consider to be just. And so it's really important to point out that people expect courts to be as efficient as possible in terms of running their proceedings, without this unnecessary bureaucracy, delays, and cost. And the Chinese Communist Party, right, has long pronounced that the mission of the courts as government institutions is to serve and satisfy the population's demand for efficient dispute resolution and effective dispute resolution. So they want judges to be more than neutral, passive umpires. And despite, professionalization efforts, judges, are still expected to go out of their way to meet litigants' demands. There's, a famous example of judges going to like the bedside of ailing people in the hospital in order to really like show that they are committed to the people. And the kind of interesting tension that is important to point out is that judges' jobs have become more demanding over time while seeing a decrease in the number of people who can qualify as judges. So, right, I mentioned before, judicial reform caused many people who formerly held the title of judge to either be demoted to clerks and assistants or to have quit their jobs entirely because they didn't meet the new qualifications. And yet, so now there are fewer judges and higher expectations on them, including these efficiency expectations, despite there being fewer. So efficiency also goes kind of out to litigants in courts as well. Like there are claims that, you can be more efficient in the service of court proceedings by partnering with companies like Alibaba. So it's actually one of the big problems courts have are physically tracking down people to serve them court papers. And there's been partnerships with Alibaba's Taobao, which is kind of like the Amazon marketplace equivalent in China, to be able to track people down by using the receiving address for their packages as the address to serve their court papers to. There's also litigant analytics tools. So I talked a little bit about tools that help litigants understand, once they've filled out their kind of court paperwork and there are systems that use basic fact pattern detection to see, well, what would the likely outcome of your case be? These are typically found on like a physical kind of computer kiosk in a court's complaint filing room. There's also within just smartphone apps, like I mentioned, the WeChat mini programs. They claimed to run predictive models, but Shin and I, from what we could read about this, thought that they were actually quite crude and just used sort of very standard data to make quite large assumptions about the likely result of the case and the estimated cost. And, the justification for this is that litigants might be less willing to file what are considered extraneous or frivolous cases, or even if they do proceed with the case, they might be less likely to blame the courts if they don't achieve their desired outcome, which, there's work demonstrating that this is one of these things people protest about for sure. And finally, the remote and online court proceedings. So the long-term goal, as I said, is for most, if not all courts to be equipped with this technology. So to do live streaming, to do kind of all of the filing digitally. And the combination of kind of 5G rollouts and COVID-19 of making this just happen faster. So transparency, one of the big initiatives that is meant to foster transparency is the creation of this database that's open source, anyone can access it, called China Judgments Online. It's now the world's largest public database of court judgments, and it's pivotal to the Smart Court project. So since 2014, the Supreme People's Court mandated that people's courts throughout China publish court judgment documents as soon as they go into effect. So it's been 6 years and tens of millions of judgment document uploads later. And that we're not entirely sure how well they've done on the goal of reducing judgment discrepancies between similar cases. Similarly, there's the live streaming platform, which went online in September of 2016. And as of May 2020, which is when Shin and I last worked on this project, they've cumulatively broadcasted over 6.9 million proceedings from over 4,300 Supreme People's Court cases. The rationale for these particular interventions, according to the Supreme People's Court, is to achieve fairness through transparency. And so the belief is that judges would conduct proceedings and make decisions that were more fair when their courtroom behavior and their written opinions are constantly monitored and exposed to this level of public criticism. I'll also say that transparency initiatives play a large part in the court's kind of public communication and outreach. So in Chinese, this would be referred to as like popularizing legal knowledge. And this is the idea that the judges and courts have to constantly reach out to make sure that citizens understand the law, and in turn that they build kind of public social trust in the court system. And again, with the professionalization efforts, it's supposed to kind of diminish this idea that judges are kind of like removed from the public in their chambers. They've talked about it as like a judicial black box that is now open on the internet for anyone to see and to hopefully dispel public suspicion. The last thing I'll say on transparency is that courts are also able to analyze viewer data on the live streaming platform so they can understand which types of cases are of most interest to the most people based on viewing statistics. And then in theory, they would spend more kind of resources on informing the public about legal issues pertaining to those types of cases. And so the mass publication of court opinions on this centralized platform has also enabled lots of research, in China among academics and kind of legal tech firms. What's interesting is Shin found that one of the kind of findings emerging from that new work is that not all provinces' courts have even satisfied the Supreme People's Court's online publication requirements for court opinions. So moving on, fairness. What we found when we looked at when fairness was mentioned was that fairness was often equated with standardization. So Chinese courts have long faced kind of complaints about disparities between how judgments in similar cases would be dispensed differently by different courts or even by judges within the same courts. And part of the reason this problem arises is because of China's kind of geographic expansiveness and regional diversity, with courts and judges trying to fill gaps in kind of the top-down statute-based legal system using sort of their own opinions. But over the last decade, the Supreme People's Court has turned to a case law approach and has a guiding cases system where they periodically publish cases selected from courts across the country as representing kind of the proper approach to adjudicating particular legal issues. And so I have my, obligatory recognition of the law school's Guiding Cases project, where there's lots of really just like rich write-ups of some of these guiding cases. And I highly recommend it to people doing research on this work. So judges are strongly encouraged to reference the authoritative annotated opinions of these guiding cases. There were a total of about 139 of these when we last worked on our paper. Of course, on-the-ground research has shown skepticism towards this, right? There's empirical studies revealing that over the years, the SPC's kind of guiding cases have actually been cited pretty infrequently. And the court leadership nonetheless still sees this as like a starting point rather than the end game of improving fairness as a form of standardization. And finally, I want to mention the push system. So there's pilot adoption across courts of intelligent systems for pushing similar cases to judges, so to the Supreme People's Court and selected high courts and intermediate courts. Tech firms built these systems to purportedly mine judicial decision databases and help judges analyze which cases are similar. Judges are actually reporting in some places that they face pressure from litigants, so to make their kind of case judgment more standardized, more consistent. And now that litigants are able to see what these guiding cases are, to look at judgments and China judgments online, they can kind of consult the past documents and offer their own opinion of where they think the case should go and how it should be decided. So now we get into the part that is like what excites me about this work, and kind of I did more of this, and Shin did more of the kind of setting the legal landscape, and that's the outsourcing of the smart court through public-private partnerships. So in recent years, courts nationwide reportedly spent a total of 168 million RMB, which is about 25.5 million US dollars annually for operating courtroom tech, and so that's about 10% of the national judicial budget. There are also roughly 7,200 staff members within the court system that work on the back end of the tech. And then there's also another 1,400 sort of technicians and technical support experts sent from the contracted tech companies that build the technology to kind of be housed in residence at the courts and monitor how these systems are being used. So one of the big examples for anyone who's been following this is, of course, Project 206 in Shanghai. which is a collaboration between courts, law enforcement, universities, and the AI startup Iflytech. Project 206 has quite a few different products. One is a smart trial system that converts speech to text for court transcription. Another is smart judge assistance software that enables judges to input case information by speaking it aloud, which is then converted into text. And these are some of the more kind of famous products coming out of Project 206. So I want to give you kind of a description of what a typical Project 206 outfitted courtroom looks like. So in one, you'd see large computer monitors stationed in front of the judge, the defendant, the prosecutor, and the jury, respectively. The judge's screen would contain display areas for voice recognition, smart data capture, and trial evidence, whereas the defendants would only display trial evidence. The judge and prosecutors are able to retrieve trial data through voice commands, such as stating the defendant's name to have their ID card and other information appear on screen, or to utter aloud a timestamp in description of an event and have that moment in surveillance video footage broadcast on the screens throughout the courtroom. According to one account, the dialogue between the plaintiff and the defendant are also converted to text in real time and displayed on screens facing the entire courtroom. So Project 206 smart court technologies, they've been implemented in roughly 4,000 courtrooms within 815 courts. As of as early as 2016, Iflytech had signed strategic agreements to provide AI-driven services in courtrooms in provinces like Jiangsu, Zhejiang, Anhui, and Shanghai, and in Yangtze River Delta cities such as Suzhou. Pilot tests of the software have also been reported to be conducted in Hefei, Wuhu, Anhui, Taiyuan, Yunnan, Kunming, and Xinjiang since 2018. So to build models that classify and assess evidence, representatives from the four districts of many in the Shanghai court system were chosen to work with technical staff from Iflytech on 4 teams divided by type of crime. So the 4 teams were homicide, theft, telecommunications fraud, and the crime of absorbing public deposits. There are other kind of highly consequential functions Project 206 has been reported to have developed, but it remains unclear how some of them are used. So the ones that I'd like to just flag are this kind of nebulous social risk review, along with prosecutor supervision and sentencing recommendations. Like on the whole, we didn't find that some of the technologies used in the United States to make sentencing recommendations are being widely used in China, but seeing that 206 is working on one was definitely a little alarming. So 206 has kind of been in the spotlight for the media, but there are other projects that have continued without as much recognition. And one of them is this wise judge system. So as early as 2017, Beijing's High Court has used this automated system known as Rui Fa Guan, which is wise judge. And it's developed by the Huayu Yuandian Information Service Company. So this platform constructs knowledge graphs. It uses optical character recognition as well as image, speech, and entity recognition of court documents. So the Wise Judge Assistant platform will recommend judgments based on analyses of historical judicial documents for cases that it deems similar to the ones under consideration. And on top of that, it makes this differentiation between simple and complex cases through means that were not kind of publicly acknowledged. The company doesn't talk about its methodology. It also has a sentencing support system that reportedly pulls from over 30 million published judgment documents to serve judges real case examples in which sentencing circumstances were similar to those of the current case, as well as offering an assessment of the impact certain sentencing decisions had on past cases. Huayu Yuandian also additionally offers its sentencing recommendation tool in Shenzhen and Guangzhou. And the company claims that automated sentencing recommendations are used in 94% of cases, which is quite high. The company claims that they continually modify their recommendation algorithm according to judges' usage habits and citations of recommended cases. And they market this is really like kind of unique among these companies, but they market this as a reflection of the system validating judges' expertise rather than undermining it.
In some instances, these tools are described as supporting the professional judgment of judges. So one example I kind of pulled from the research is in the second criminal division of the Qinhuai District People's Court in Nanjing. In 2016, the court's presiding judge heard a traffic accident case in which she used an early warning system for different judgments in similar cases. And the system recommended a 2-year sentence, which the judge disagreed with based on her understanding of both parties' family circumstances. But once she input a letter of understanding, which is a formal document similar in cases like this, the sentencing recommendation recalibrated to align with cases containing this additional document, changing the sentencing recommendation to between 1 and 1.5 years. And the judge felt that this reflected her professional appraisal of the case, and lauded the system as, quote, enhancing our confidence when making judgments. So the final example, and one of the kind of biggest ones, is of course Alibaba and the Zhejiang court system. So, I mentioned the Hangzhou Internet Court, which is partially integrated with Alibaba's e-commerce platforms, not only to capture information like receiving package address, but also consumer transaction information for adjudicating kind of disputes that involve Alibaba companies as well. So, and also for ensuring that there's proper identification of litigants. So as we mentioned, there's Alibaba's Alipay uses real name registration. So that's like independently verified that the account tied to this person verified that they are who they say they are. And there's use of facial recognition within Alipay and WeChat that courts can use to identify people and verify people's identities. So since November 2019, Alibaba has also partnered with the High Court of Zhejiang Province, which is where Hangzhou is located, on a smart court system that uploads litigants' information to their trial cloud and automatically files complaints. So this platform can incorporate data from public security and government affairs institutions, along with financial, e-commerce, social networking, and transportation information where relevant. And it's only one of several court systems within China that have partnered with Alibaba on this. So Alibaba frames it as, this pain point of having many cases and too few people to handle them, which, as I mentioned before, is partially because of judge professionalization. And they've also supplied the Zhejiang High Court with an AI-powered judicial assistance system called Xiaozhi, and it's like intelligent for people who know Mandarin, which conducts evidence analysis and generates automated judgments at the end of trials. So this was developed at Alibaba's Academy for Discovery, Automation, Momentum, and Outlook, which is like a kind of research institute within Alibaba. Xiaozhi uses text-to-speech, speech-to-text, OCR, and NLP, natural language processing, classification and extraction, as well as logical reasoning algorithms to perform functions including pretrial review of documents, scheduling hearings, automatic case filing, real-time speech recognition during a trial, evidence analysis, case outcome prediction, calculations of penalties to be paid, and automated generation of judgment documents. And as I think I might have mentioned, but in case I didn't, I also want to point out, from Alice Mingay and other people's research that Alibaba is the defendant in over half of the cases heard at the Hangzhou Internet Court, given that a lot of these involve Alibaba's own platform. So they're really kind of tapped into lots of the data generated from those kinds of cases as well as others, and then that gets fed back into these analytics products. So now we kind of want to move to, I've given you so much kind of description of these systems, but I want to talk about the challenges and limitations. And I think something that I don't see enough of in writing on China is what the perspectives on those challenges and limitations are from within the country. So some of that is blended into like Maria and Xin's kind of understanding of this topic in our analysis. So one of the efficiency challenges is that despite the Supreme People's Court updating their last 5-year plan on like court reform, their ambitions were hampered not only by a lack of institutional confidence in these kind of nascent smart court technologies, but also by issues with the court's fragmented data systems. So they haven't met kind of the standards for interoperability. And this is a problem I see, in my work on social credit as well. It's called data islands, this idea that different government institutions don't have interoperable systems because of the ways in which their data is not uniformly formatted or stored or shared. Very relevant to Angel's work is that judges also tend to be unhappy about using these systems in part because there's more bureaucracy for them now, and these checklists and sort of forms that are checks on their work that they have to fill out. So again, some of this is in response to that Peking oversight mechanism, but also many judges, including older judges, are distrustful of and resistant to the introduction of AI systems in their courtrooms, and are fearful that machine error can affect how they handle a case and can detract from years of legal expertise and embodied experience that they have. While speech recognition recording devices that are used to create transcripts of court hearings are widely celebrated in the media, they can only recognize standard Mandarin and a few dialects, and their accuracy remains pretty low. So we've actually found examples, descriptions of how there's difficulty in identifying different speakers, which has resulted in court staff having to go back and amend the transcripts themselves after the fact, which is of course a stumbling block for this efficiency claim. And despite widespread claims that the Smart Court project will bring kind of transparency to China's judiciary, the process through which the technologies themselves are designed, tested, and adopted remain largely unknown. So they talk about how, that kind of divorce in bringing the technical expertise and judges' expertise together when developing these products means that interfaces are created without judges' input. And then judges will find the user experience cumbersome and unstandardized. So this is referred to as a technical gap. And it's partially a transparency problem, but it becomes an efficiency problem when judges have trouble figuring out how to even use these systems. Plus, they mentioned that court staff themselves are likewise not AI experts. So there's a cap on their ability to continuously monitor the possible errors that would emerge when data is extracted from case documents. So discussing kind of other transparency challenges, there's regional variation with respect to how well local courts will perform these kind of digitized duties. There's studies that reveal potential selectivity among the types of cases that become publicized. So we mentioned, the live streaming court proceedings, they're very selective in terms of which cases are chosen to go live. And there's this vague category of educational value to society as the criterion on which those decisions are based. Although some local courts are moving towards just the decision of making all cases live streamed, so that would make it kind of a norm rather than an exception. Yet to be tested also is whether live streaming renders courtrooms more performative, or it would make them kind of more scripted and by the book than in in-person court hearings. So, we looked at how live streaming court sessions imposes new pressures on many Chinese courts that are now facing even greater understaffing problems given the personnel reform. There's also heightened privacy risks that have yet to be addressed. So live streaming sessions, always run the risk that private information might become, leaked to the public unexpectedly and perhaps irrevocably. This is not just about judges and clerks' personal identification, their likeness, their physical traits and courtroom manner being subject to this kind of outside scrutiny. Some of it might not even be related to their job performance, right? One can never know what might go viral and why. And while we were writing this, should noted interestingly that in France, there's actually legislation that was passed last year prohibiting data mining and analytics of judicial decisions that involve the processing of identity-related information of judges and clerks. So that made it basically impossible for French academics and the public to run kind of judge-based judicial behavior studies as those done in the United States and potentially in China. And the last thing I'll say about this is that there's a power differential in which courts, so it's a power differential kind of determining which courts are able to be transparent in this particular way. So one Chinese scholar noted that even though there's been much ink spilled in Mandarin and in English on black box algorithms, here it's the data collection, the selection standards, the adjustments and choices about model building that constitute their own black box. And so she uncovers the professional pressures that contribute to this opacity in gesturing to the professional pressures the judges face of increasing their workload in order to upload documents to China judgments online. In grassroots courts in particular, rising caseloads have made it even more of a struggle to close cases while also making their information public in a timely manner. And many of these grassroots courts lack the technological facilities, the human capital, and the stable internet access even to upload documents within the time they're required to. So going back to fairness, The push system itself has been questioned pretty widely, right? So there's technological shortcomings to it, but people are also skeptical of whether any algorithm can be designed to meaningfully tell a judge which cases are similar and which ones are kind of distinguishable from the case under consideration. Some people have also pointed out that the Supreme People's Court has not developed a systematic theory for its proposed case law methodology, which can't be a direct transplant of the common law method. So without a more fully developed theory, it's difficult to address the question of why fairness requires treating like cases alike, especially the way the Supreme People's Court is setting out. So judges are expected to use the push system as informative rather than authoritative, but there are some anecdotal reports that suggest some courts are pretty aggressive in implementing requirements for judges to use the push system. There's concerns that have been raised about potential algorithmic bias. Judges might be forced to agree with the system's potentially discriminatory recommendation or to disagree and then have this divergence leave a trace in the system that is assessing their performance as a judge. And a major concern we saw echoed throughout policy documents and critiques of the Smart Court project involved the provenance and quality of the data used to train the models. The case data that courts hold is siloed across different departments and information retrieval systems, right? These information islands or data islands. For all of the praise the China Judgments Online, judicial document network has received domestically, lawyers actually note that it still lacks information about how a judge arrived at a decision. And that includes information that's been recorded, such as transcripts of court hearings, records from the judges panel, and judicial committees' decisions. Some Chinese scholars are beginning to make a case for closer interrogation of how training data corpora must account for historical data's utility with regard to legislative reforms and regional differences in how laws are enforced. So in larceny cases, for example, different provinces, autonomous regions, and municipalities that fall directly under the central government can set standards for specific amounts of stolen money or property in accordance with the economic development of these respective regions. So again, like what counts as kind of a high amount of money in Beijing might be completely different from, a grassroots court in like a small rural area. The last thing is that some critics are concerned about potential path dependency and judges' reduced autonomy that may result from over-reliance on these systems, right? Automation bias, calling for explainable machine-derived decisions. So explainability, the other kind of value that gets brought up with fairness, accountability, and transparency, and interpretable algorithms to enable judges to retain control. So kind of coming to the closing here, I also wanted to point out like one direction this project is hopefully going to go in is kind of comparing this to courtroom automation in other places. So, courts in other parts of the world, in part due to COVID, are live streaming cases that creates this body of data. Like, there's examples in Nigeria and Singapore of like the death penalty being assigned to cases that have been heard on Zoom. And fear that as states that are willing to do that are also interested in court automation, that they can kind of reproduce certain harms. The UK, Canada, they're moving more towards online self-service platforms. I don't know if people have heard about the robot judge in Estonia, but it's essentially just a trial for adjudicating small claims cases. So essentially litigants would file their paperwork, an automated judgment would be suggested, and human judges would make the ultimate decision. So I'm going to end on the questions I hope we keep asking, which are mainly, when do courtroom automation measures provide meaningful data citizens can use to hold courts accountable for rights violations? Who is affected by transparency efforts and courtroom initiatives? Who does this serve? And which smart court technologies should not be developed and applied? And yeah, I'm ready for questions. Sorry that went a little over time. There's a lot to say.
Thank you so much, Shazeda. This is such a great presentation. And, there are many questions in the chat. And so perhaps I'll start by kind of putting together a couple of questions and kind of bringing them with like a question that I had. So Arjiri, Jana, and Fernando had questions about how specific are these findings and the kind of both the technologies and the kind of landscape of like courts plus technologies that you show here, how specific is it to the Chinese context? And I think that here, that was also kind of my question listening to your presentation, because as someone who has done research on kind of digital technologies and courts, both in France and in the United States, I was really struck by the similarities between so much of what you're describing and like what I've seen both in the EU and the US context. And so just to name, like, I mean, I could actually, I think I could count them on like at least two hands, but like, you know, the part about efficiency and the kind of current discourse of like courts being this kind of inefficient monsters, like inefficient bureaucracies that need to be kind of streamlined through technology, very present both in the US and in France. The part about standardization and both the kind of risks and benefits of standardization, also very present both in the US, starting with the sentencing guidelines of the 1980s and all the way through risk assessment tools, right? The same kind of language around standardization. Language about structured decision making, right? Like, oh no, the algorithms are not going to replace judges. They're only going to help structure some of the information that they're using in order to make decisions, right? So like same kind of thing. And I could keep going. I mean, I just two last things because I find this really interesting. So part about individualized judgment, right? Like, so to what extent is the judicial judgment, to what extent should that be individualized versus with risk assessment tools and kind of algorithmic technologies, well, you're compared to similar cases, as you mentioned. And so what are some of the legal challenges that go into that comparison? And the last one, which I'll mention, is the part about regional difference. Also very present in kind of practitioners' debates about risk assessment tools, right? As in like, how should the tools be calibrated? Should they be specific to like one jurisdiction or one kind of geographic area, which has, for example, specific, you know, I'm thinking of like unemployment rates, for example, right? Or like drug use rates, like lots of specificities that are going to impact the ways in which the results provided by the software program should be interpreted, versus like, oh, we're using these software programs at the national level and it's kind of a one size fits all kind of thing, and just like you deal with it. We don't need to like contextualize this. So all of this to say is that I'm really curious about what do you think is specific about the Chinese case? And I think there are several layers to that answer, right? Like the first one would be, well, some aspects of the technologies you mentioned are unique to the Chinese case. I think, for example, the live streaming data, that's fascinating. But you know, a second aspect from what you were saying is also the question about judges' professionalization, which seems to be very specific to the Chinese context. And of course, but I would love to hear like what you think is going on there that is different from other kind of judicial systems and other national contexts.
Yeah, thanks for all of that. So for the first one, which you brought back around to the end, thank you. I part of what I was hoping in doing this work, and like I really hope it doesn't come across as I like shoehorned it into this critique that, oh, we're all the same, right? Is really trying to figure out what was different. And you know, if we had done this comparatively, we would be able to say, like, provide this kind of rich description you just did of what you're seeing similarities in France and the US. So yeah, most of it, you know, there are a lot of similarities, but to me, I think part of what makes it different, and the professionalization goes to this as well, is that it's like a state legitimization project. Like, on one level, these technologies are supposed to serve the particular actors they're designed for, but on a higher level, they're supposed to say, look, the Chinese government has invested so much money into making the courts modern and fair and transparent and something people can participate in and have opinions about. And again, with this idea of judges as more than just the, you know, umpire, but as like performing a service for people that they have to be satisfied with. I see that as pretty unique to China, and it would come out of, like, if you asked what is it in response to, it's in response to decades of people feeling like the court system is, you know, unfair, unjust, that it's not worth pursuing their cases, that no one's really on their side or cares about their problems. Like that's, I think, at the core of like some of what we're seeing. And you know, and if you look at it that way, it explains also things like live streaming, which
unfortunately now is not unique to China. But when we were looking at some similarities, like in the United States, we have court watchers, and the Marshall Project has this really great piece about how court watchers can't physically be in courtrooms now, and they often are struggling to get the Zoom link to cases, and they were a check on transparency. What does it mean to have this live stream to anyone who wants to watch? And then can it become, a data corpus for assessing some of these questions we had about what is it like about a live stream case that would be different? Are people presenting themselves differently? Or like there's all these cues that we're going to miss from being in person, but then all this data that is being created from doing it remotely, that I'm really curious to see what, I mean, what will probably happen is more products will be developed around that, but I'm also curious about if researchers are going to look at that and kind of come up with an assessment that this creates these new pressures that cases will be decided a particular way, not necessarily for the better. And the second question you had was about individualization. So I think it relates to some of the points I just made, that like, one, creating all these open systems in theory means that individuals can kind of do their own digging, and not necessarily accept, like with the data analytics that I pointed out right at the beginning, where it says this is the percentage chance that you'll have this particular outcome in your case, this is how much money it would cost you as an individual. It's funny how that gets framed as empowerment, because it might save people time and money. But at the same time saying, oh, but all of this judgment data is available online. You can research it yourself. Like, you don't have to trust the expertise of the judge if this is available to you. Like, I'm really curious about how they're going to deal with some of the contrasts in some of these claims of what the technology can do. Also, reading that, I thought, in what situation would someone say, okay, I'm just going to sit down with the world's biggest database of court judgments and try to, hack this out myself? Like, I'm very skeptical of these suggested uses of these technologies and if it will actually lead to like individual satisfaction. And then the third point about sort of standardization and regionalization, I'm really glad to hear that that is a problem elsewhere, because in some cases, so like the example, the reason I brought up all these places when I talked about Project 206 is it was developed with 4 Shanghai district courts. Shanghai is a province level city. It is very wealthy. I'm glad to see Chinese scholarship bringing up the regional point, because if you then go and impose this system in all these other courts in cities I mentioned, and I'm saying the names of cities, but like, what part of the city, what kinds of resources does it have, what level of court, like it's just like a field where there's so much room for empirical work. And unfortunately, when Shin and I agreed to write this paper together, it was before the pandemic, so I thought I'd be going back to China. I could hop into some conferences, do my usual like finding the business cards and WeChat contacts of the companies and talking to them, and none of that has been possible for me this year. So unfortunately, some of these questions I'm not going to have answers to.
That makes a ton of sense. So there are lots of questions which we probably won't have enough time to go through, but a couple of ones. So first, a question by Gabrielle De Seta. I'm curious about the companies developing these tools. From the examples you mentioned, besides Alibaba, there seem to be quite specialized companies. Is Alibaba the only large tech company involved in smart courts? And has the Chinese government identified national champions for AI in courts?
So, hi, Gabriele. And I think the national champion or national team idea, I would recommend checking out my colleague Benjamin Cedric Larson's work on this. Like, he had a piece for DigiChina where he actually mapped out who the national team champions the state is picking in different fields are. And there might be one for legal tech, but I don't recall. And so I mentioned IFLI works with Project 206, and I think they're kind of big enough. I'm starting to see them pop up more. And financial, Tencent has done some things certainly to make these WeChat integrations possible. I don't think I've seen other of like Baidu or JD working on this, the other kind of big companies. But so getting back to this point of it being small companies, this is like a big part of this work and the social credit work and just anything I do related to China, is that there is this differentiation in the market. Like, there's so many, probably countless companies working on products like this, partially because the market is created by this point we made about regional differences. So there's a whole procurement order bidding processes where you can essentially bid to provide the court
platform for Guangzhou or for, a particular city that doesn't feel like it's necessarily represented through these other technologies, or where, the national kind of AI development plan that trickles down to like how particular provinces and cities fulfill it will get funding and want to pump it into projects like this. And so Shin and I actually have another paper we wrote that we have not published, where we kind of map out that difference of like, what does it mean when a big company builds something for kind of an under-resourced region versus like a Shanghai, and small companies, like where do they operate and why, and what is different about the services they provide? So the answer is we're attuned to that difference, and it matters, especially if these technologies are designed to be used in one place and then get implemented in other places, or if they're not.
Great, that's super helpful. We have a question from Madhu about methods, which I'm also really curious about. So Madhu asks, do you think it is possible for researchers to access the decision-making systems you mentioned to examine the reasoning behind the model? Is this a desirable goal in order to further study the FTA of the system? Thanks for the excellent presentation. I had to include the compliment as well as the question, right? And so I guess like, it's a broader question. Is like how, and like I'm also curious as someone who studies that kind of topics, how do you access the information you have access to? What's your method for studying these questions? And what do you think are the main challenges in kind of providing this kind of on the ground kind of study of how AI actually works?
So I want to preface this by saying everything I presented to you here, I did, at my desk. Like it was looking at Chinese academic databases and then following the crumbs of this particular company, this phrase for a product type, and then just kind of searching like Baidu, Google, finding other articles and building out our set, and then kind of, it's like a cycle, right? You go back to the academic papers and look for something new there. And what I know from fieldwork is you could have this whole paper written and then show up on the ground, and the reality is way less interesting or way, that like things are particularly overblown by a company trying to sell its product. And so you have to inject some of your own skepticism for things you can't find out. So of course, not being able to go to China, it's really hard to kind of follow through on some of this. If I were there, as I said, I'd be trying to go to conferences, trying to see how these companies present themselves publicly. Something I learned from fieldwork is that a lot of well-connected Chinese academics actually have pretty good access to companies, and they have off-the-record conversations that I think guide what they write without them citing it. And I'm sorry for all of my Chinese colleagues if I just totally blew up your spot. But like, yeah, people, will say in conversation, I did talk to, this data scientist at this company, and this is what I know, but you'd never cite it in your work. You would just say things that dance around it. And Angel nods knowingly, so perhaps this isn't an open secret around the world for every country's tech industry. And so, I don't know if we'd get that kind of access, but that's something I always think about when I read pretty well-informed and unique takes on some of this in Chinese scholarship, is the possibility that this scholar met with someone in the company they write about. And to be fair, my approach of like picking companies and then just really deconstructing everything they say and bringing it back into the context of everything else that's been written, it's not a super common one in the Chinese literature. Like the companies might get name dropped here and there, but there's more of this question of like the entire suite of possibilities for a type of technology or a type of method. So I have to acknowledge like the way I'm doing this is very like industry centric and certainly informed by like my training here in the US, and it's quite different from what I see in China.
That's absolutely fascinating. Yeah, and I think that about the question of like on the record versus off the record. Well, for people studying technology, and especially technology companies, right, the production of technology, and for people studying courts in a different world, these are two sites that are very difficult to access and get information on. And so I think that off the record information has been a big part of it for a while now. So anyways, that's for further discussion. So there are many more questions, but unfortunately, we are coming to an end of this session. I think that I would like to conclude by asking you, well, two questions. The first one is this paper published? And if so, where? And can people access it? And second, kind of asking you a question about the next steps of this research. What do you have in mind kind of moving forward? And especially in the context where with COVID-19, as you say, research on the ground may not happen exactly the way it did. And so just asking you about future research.
Thanks. So as I mentioned, I would love if anyone who is working on this, whether in China or in another geographic context, just could get in touch with me. You know, at my Stanford, kind of just find my page and email me. I'm not on social media really, because I want to come up with kind of like an edited volume of like cases from all these different places, and then we can kind of read them all in conjunction with one another and figure out what the overarching themes are. This was a presentation from a first draft, essentially, that Chin and I submitted to the Privacy Law Scholars Conference, which is a workshop earlier this year. We have not worked on it since. I need to get in touch with him and figure out, you know, where we're going with it. But the goal is if we had this kind of like, you know, the compendium type piece to write for, that maybe we would put it out through something like that. And yeah, the hope is also to get this out as a paper at some point. You know, we live in unprecedented times, Angel, and it's been hard to know if and when we're going to get this going. And if there's going to be a fieldwork component, it will have to be in a separate paper a long time from now. But thanks for asking.
Great. Well, thank you so much. Thank you to everybody for coming and attending and asking such smart questions. I will share all the questions with Shazeda. And also, if, as Shazeda kindly invited, if you have questions that you would like to ask over email or by getting in touch with her, or if you're working on topics that are in the same kind of broad kind of area, please get in touch with her. And I'm just super excited to see this new work and to see how it's kind of connected with your social credit system work and how it works really well together, and helping us kind of understand the concrete ways in which these technologies operate in the Chinese context. And I think it raises fascinating questions. So thank you so much, everybody, and have a nice day.
Thanks, Angel.